There we go. All right, go ahead.
Okay, I'm going to do this in three parts. I'm going to give you the international law as well as just the convention law itself on the child abductions. Article 3 and 4 and 5 deal with what is a wrongful removal and what rights are attributed to a person who has had a child that has been adopted. And the first part of it is under Article 3 of the convention itself, which says that a removal and retention of a child is considered wrongful where it is a breach of rights of custody to a person, an institution, and any other body, either jointly or alone.
Dan, I'm so sorry to interrupt, but could you just introduce yourself briefly too? Just say who you are and how you got involved with this.
Sure, yeah. My name is Dan Mason. I've been involved with child abduction cases since probably 1991. And in fact, my own child was abducted at one point, but that was way back in the past. My case was successful, but a lot of others perhaps weren't as successful as mine was. So I'm just going to give you, at the end of it, my case perhaps, as a way of saying this is what a successful application really looks like. So I'm actually part of the Foundation for Justice and Social Ethics, and dealt with many areas of human rights violations in various categories under that particular foundation. But in particular, of late, it's been getting back involved with wrongful removals of children to other countries. So that's who I am. So should I continue on here?
Is there a way to turn up the volume? Because I'm struggling to hear you.
Yeah, Dan, your volume is really poor quality. Like your audio is. Do you have a headset or anything that could improve your sound?
Well, I'm going to bring it down a little bit. How is that? Is that better?
Your audio is pretty bad. I can hear you. Can you guys turn up the sound? Is there any way you can improve your microphone isn't working very well, Dan?
Headphone's not working?
Well, it's your volume is very low. Your audio is not good.
Turn it up. How's that?
That's much better.
Is that better?
It is for me. What do you guys think?
For me, it hasn't changed. I don't know why.
Can you hear me well enough now? Well, I'm going to try to move closer to the microphone and see if that helps. How's that?
Yeah, it's a bit better.
Is that better?
Yeah, I
Yeah,
can
it's
hear
not
you.
great, but yeah, we can hear you.
I'll bring it up more. How's this? Is that any better?
Yes, I think you can carry on with your presentation now.
If we can carry on?
Yep.
Okay. Under Article 3 of the Convention, the removal or retention of a child is considered wrongful where it is in breach of rights of custody attributed to a person, an institution, or any other body, either jointly or alone under the state in which a child was habitually resident, immediately before removal and retention, and at the time of removal and retention, those rights were actually exercised either jointly or alone, or would have been so exercised but for the removal or retention. Okay, and the rights that we're talking about here rise by operation of law, but primarily from what the convention focus is, not necessarily by the law in a particular state. This is kind of important. I'm going to come back to this a little bit later, but then Article 4 says that the convention shall apply to any child who is habitually resident in a contract state immediately before breach of custody or rights access rights. And the convention shall cease to apply when the child becomes the age of 16 years of age. And the rights of custody include rights related to care of a person, child, and in particular the right to determine the child's place of residence. Rights of access shall include the right to take a child for a limited time to a place other than a child's habitual residence. Now, in this area here, the removal and retention is the key area. The person had to have access to the child or rights of custody to the child before the child was moved from that country to another country. So say, for example, it's in Canada and the person had access rights only, they still have rights of custody. If they had joint custody, they still have rights of custody. So if the child was moved to another country, then the child would have to be removed from that country and returned back to its habitual residence. Now, this actually comes the case for about a period of 2 years, and I'll get into that more later. But primarily, the idea is that the child has to be sent back to the country it came from, because the best interest of the child is that the child is in its habitual residence. That's really important. So what's in the best interest of the child, according to this convention, is that the child actually had a home. Being removed from that home is not in the child's best interest. And this kind of gets run a kind of aside. Another part of this convention is Article 21. Article 21 deals with the concept of a child being in another country and that the children and the parent have access to each other. So this organizes, secures the effectiveness, access of rights of the access. And the central authorities of contracting states are charged with making sure that this happens. Now, I'm going to go to another law, which is kind of important, because the way the convention works is that it works in conjunction with other conventions, and in this case, the Convention on the Rights of the Child. And in here, you'll see that the United Nations proclaimed that childhood is special care and assistance, and the family is a fundamental group that is involved in the taking care of the child. And it says, states parties shall recognize and respect the right of the child who is separated from one or both parents to maintain personal relations with and direct contact with both parents on a regular basis, unless it's contrary to the child's best interest. And states parties shall respect the rights and duties of the parent, and when applicable, legal guardians to provide direction to the child in exercise of his or her right in a manner consistent with the evolving capacities of the child. No child shall be subject to arbitrary or unlawful interference with his or her privacy, family, home, and the correspondence, or to unlawful attacks on her honor or reputation that applies to his or her. The child has the right to the protection of the law against such interference or attacks. That's a Child's Rights Convention, and that's kind of important because the conventions internationally all work kind of together. And in the Universal Declaration of Human Rights, no one shall be subject to arbitrary interference with his privacy, family, home, or correspondence, or attacks upon his honor and reputation. It basically repeats what the Child Rights Convention says. And men and women of full age, without any limitation due to race, nationality, or religion, have the right to marry, found a family, and are entitled to equal rights as to marriage, during marriage, and at its dissolution. Now, these are important concepts that are conventions that agree with each other. Part of the problems with the convention, however, it does have barriers. Now, one of the things that is in here and in the convention as well is that there's a few bars. One of the bars is that there has to be great risks of harm, which is both psychological and or physical, before a child is expected not to be returned to their habitual residence. And in Canada, we run into this as a real problem under the country's best interest of the child rules, because then there, particularly, any kind of claim that the child has had or is going to be experiencing any kind of harm is heard in the courts. And this is basically one of the big barriers here in Canada, because if somebody complains that the child could be harmed or would be harmed, and any false allegation complains that that might be the case, the courts hold the whole thing up until 2 years has passed, in which case that the child has a new habitual residence, which is in the other country, not in its habitual residence as it originally was at the beginning. So this is where we run into a lot of problems. But having said that, there's a number of things that come into play here. And I was fortunate enough in my case, and in the early days of about 1991, that I was in touch with the Secretary General at The Hague, who was actually in charge of getting the convention into effect in each country. And so I hooked up with him because basically there was no one else who would give me a hand on it. So he decided he would help me, and so we came to this, and this is a document that he did up for, and with me, as a matter of fact, I authored this based on his talk in New York. And so in here, he talks about the various kinds of child abductions, and this particular case, civil abduction, is what it is when you're dealing with families. And he gives a remedy of how to treat the abducted child and how to adopt the Hague. And basically has to say that the prompt return of the child is the most key part, simply by administrative or police action. Now here we find that this should have been done. Each country has central authorities. In Canada, we have 12. Each province has its own central authority. So a person who puts in an application for the return of the child should only have to go as far as having simple administrative or police action to have the child returned to the country. And if not, very summary legal proceedings with extremely limited grounds for a court to refuse the return of the child. We're not seeing this happening anymore as much as it should be. And this is causing a lot of problems with abduction cases at this point. And one of the other factors that comes into this is that sometimes a parent takes a child to another country on the idea that perhaps they can get a better case than they would in their own country. So part of the convention says, when it comes to the other areas within the convention that talks about what the central authorities must do, is to stay any applications in the country where the child has been taken. Once it's known that the child may have been wrongfully removed. So in doing that, no one gets a benefit for having, say, taken the child to another country and hope to be able to establish judicial proceedings in the new country and hopes to be able to get better, I guess, case law. So the whole idea of the convention is try to get voluntary return of the child. And where that isn't the case, well, this is where you end up with courts. And then you look at what is access rights, what is custodial rights. And here, this is where it gets a little bit confusing, because some people think that custody rights is actually because they have full custody. No, this is not the case. You can have just access. You can have joint custody. What it's basically saying is that you don't have a right to haul your child around to a different country in hopes to be able to get the child alienated from its other parent. And in fact, a abduction case is basically a means of parental alienation. And this is one of the things that tries to stop. Okay. And the other part of it under Article 21 is to make sure that the rights of personal relations with the child and the parents are both respected, and that that happens in both countries. So trying to border hop is not a good thing. Now, part of the problems that came into the convention after it had been installed in the country, and in Canada it was ratified in 1984 and enforced in 1987. But often what would happen is a lawyer would say, maybe we can do something here to get where the child doesn't have to be returned. In this case, Adair looks at the idea of the fact that that's against the rules of ethics of a lawyer. However, that never proved out, really. Because in some of the cases, well, the lawyer's doing its duty to its client, but that doesn't make it right. Okay, so what ends up happening is that you end up in a court, and then you're arguing whether or not there's a breach of rights of custody or not. But again, In Canada, this has one other additional problem, especially in Alberta, where a parental right is not something that's automatically attained simply because you're a parent. In Canada, you have the idea that you're a subject of the crown, for example. And because you're subject to the crown, you don't have a right until the court gives you that right. This is quite different from what the convention really envisioned when it was first started. So in this case, one of the tests is the rights of custody means that in particular the right to determine the child's place of residence. So if you have access, for example, and you've been having access and suddenly you no longer have access, well, that's a breach of a custody right. And if you're a joint parent with joint parenting rights, also again, you were exercising that right until the child was removed to another jurisdiction. And so therefore the rights of custody are not depicted jurisdictionally. It takes its meaning from the scope of the convention. So as it goes on here, the right of custody also is right to be consulted and give or withhold consent. Now in this area, this is where a parent having a right of custody, which most parents do, when the child is removed from the country to another country, that right has been violated. And as such, that child should be returned to the country of its habitual residence because that is the main area of the child's life. And therefore, in the child's best interest to make sure the child is returned there. Okay. Now, these are important. And so now we know what a wrongful removal is. We also know what joint custodial rights are according to the convention, and we know what the Convention on the Rights of the Child says, and what the Universal Declaration of Human Rights say. And basically what it rolls down to is that you can't take a child from one country to another country with the idea that you're going to get a better position and custody of that child when the courts in your own country have not given that to you. And even if they did, you still would have a right to contact with that child, even if you are in the other country. So here, this is where we're going to get into great risk. This is where Dyer says and is very, very keen on the idea of attempts of a person to oppose the return of a child to the habitual residence on the basis of non-grave risk, because this is a bar, grave risk. If that bar isn't there, the child has to be returned. And also, the other parent has a right to see that child in that other country. And under Article 21, it's up to the central authorities of the countries to make sure that the child has access to the other parent. It's not a money thing. So if the parent doesn't have money, well, then it's up to the person who abducted the child to make sure that they pay whatever travels necessary to make sure that the child sees the other parent. And this is actually where Canada falls down, right here. Because the battleground that's currently in place in Canada is that the persons who remove the child to another country simply say that the child may be, or they make a false claim and say the child is in harm's way, and or the child has been hurt by, or something like that, so that the courts hold it up. And in a number of cases that I'm dealing with now, a lot of the courts will simply say, okay, there's a claim that there's harm, and we're not going to look at the grave risk part of it. We're just going to look at the fact that there was some claim that the child could be harmed. And if that being the case, then we will make sure that the child stays in the country until we find out if the other parent's okay. But in the past, in about 1991, no one's been successful. This is the current law now in Canada, uses the best interest of the child as a case-by-case basis, based on what the judge simply thinks that they should do, and not necessarily what's right. So when we're looking at this, the best thing for it to happen is to make sure that you get some kind of a outside assessment done of the child and the parents to make sure that the facts are in place rather than the false accusations and claims that are in the courts and that's been filed. This is kind of important. Now, this is the actual form for the application. This is actually what is done in the central authority for another country. This is a form that they use to actually have the child replaced or taken back to the country of their habitual residence. This is a form that's being used. Now, I'm going to go to, now I don't want to take too much time here. I promise only half an hour, but then I'm going to go to a case. And my case was very successful. So I'm going to just use my case because there was a claim of harm in my case, which was in the end proven wrong. What happened was that in Court of Queen's Bench, we were at the point of getting custody. I had made an application for that custody, and at that point, then they decided they were going to take my child to the United States, in particular to Arizona. The lawyer I had at the time, I asked to use the convention, and the lawyer said, I don't know anything about the convention. I don't know how to even proceed with it. So I really can't help you there. And she said, but I do know another family that's having the same situation you are. In fact, their children have been taken to the same place yours has. So she said, I should put you in touch with them. And I said, that's okay, you could do that. So at that point, realizing that I wasn't alone, I had talked with, his name was Greg, and said, you know, if you want to come in with me on this, I will do it, but I will have to do this one on my own, it looks like, because our lawyer, because I have the same lawyer he did, doesn't know what to do with it. So I contacted The Hague in the Netherlands, and I said, could you refer me to somebody who can help me with the convention in this application in Canada? And at that point, I got a call back from a Dergaar who just happened to be the Secretary General at The Hague. And so he helped me through it as far as what to do next and what to do next after that. So the first thing I did, though, was to get a outside chartered professional psychologist to do a full assessment of all parties. And then I went to the court with that application to do that, with the convention labeled in the application and noted. The judge went ahead and did order that the assessment take place. As the assessment took place, she interviewed me, my friends, my family, interviewed the other side's friends, family, and came to the conclusion that, and this was the important part of it, really kind of creates the whole thing, that there was this, he come to the conclusion that there was nothing said in any of the allegations that I would be capable of doing. And that sealed it for the court. At that point, then the court ordered that the matter go to the Arizona court. At this point, I was in the Court of Appeal. So at the Court of Appeal stage, they simply referred it to Arizona. And Arizona is kind of the head of the whole game because they had William Fabregas down there, and he basically had already gone the courts into the groove of what should happen in a convention like this. So the Arizona court, within about a 2-week period of time, ordered the child to return to Canada. And then from there, what would happen was that there would have to be, and I could go ahead now with my case for custody. So after that had gone through the Court of Appeal and then back into the Court of Queen's Bench, I asked for case management. The case management judge then said, okay, what we'll do is now that your daughter has to be returned, she can stay with the aunt here, and then you guys can make arrangements to, you know, travel back and forth. So basically, that point, I got custody. Because at the first step, they refused to return the child, even though the court ordered it. And the Arizona court then contacted the border people, and then she was sent back to Canada. And from that point on, my daughter had full access to both families, mine and her extended family on the other side. So that's a successful case, but that doesn't happen very often. But like I say, one of the more key things that happened here was that I got someone to say that there's no way that the claims that are being made against me could be accurate because I'm not capable of that. That was important because that's what really kind of sealed the court action in the Court of Appeal. And that's why the return actually happened. So I'm running into cases now where that's not happening. And for whatever reason, people are not wanting to get these assessments. But the assessments are actually kind of critical and crucial and something that should be done. Once that's done, and then there's realizing there's really no harm after all, even under the Canadian best interests of the child rules, there's still no reason not to return the child. So that's what I hope that in a lot of cases I see and I've been seeing lately will happen. And if more of this happens, the more it does, the better it's going to be for other people who have their child's abducted. Canada right now is probably the worst country for abductions because of the rules on the best interest of the child. Because all they have to do is they tie it up in court, and if it's tied up in court, then the child will become habitually resident in the other country. And that's not what the convention is all about. The convention is against that. So I think I'm out of time now.
Thank you so much, Dan. Do you have any time for questions if anybody has one? Anybody have a question for Dan?
No.
No? So you went over, Dan, you just went over the Hague Convention and some of the international documentation. So I'm just going to stop the
I went over the 3 conventions that are international law.
Yeah. Okay, I'm just going to stop the recording.